Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. And hello and welcome now to our 9th podcast. And we want to start off today straight away with thanking one of our listeners who left a positive review, a very positive review on, I think they call it Apple Podcasts, but I may be wrong on that one. And we just wanted to thank Cole, I think was the name. Thank you very much. We're delighted with that review. And of course, if anyone has anything positive to say, please do let us know. Yeah, thank you from all of us. And if you have any comments or ideas, of course, you're very welcome to contact us on our email address, which is unpacking.contract.law@gmail.com. Okay, and today we have the fascinating case of Triple Point Technology and PTT. It's a long-awaited Supreme Court decision, and the 5 judges, I believe, were Lord Hodge, Lady Arden, Lord Sales, Lord Legat, and Lord Burrows, with, I think it was Lord Sales dissenting, and Lord Hodge agreed with him. Unfortunately, we didn't hear from Lord Burrows, as we were saying in our pre-podcast meeting. But there we go. There'll be other opportunities. Although the case involved a software contract, which I must admit tends to send shivers down my spine, the facts in this case were actually fairly simple. PTT were to provide a software package to Triple Point, and they were to be remunerated at various key milestones of the project. The contract contained a liquidated damages clause. I think it was at a rate of 0.1% per day, up to the total value of the contract, up until the point that Triple Point accepts such work. Now, that's something that we'll come back to, I think, in our discussion. Now, unfortunately, PTT finished the first stages 149 days late, at which point Triple Point then terminated the contract. And the issue that arose from that particular point was whether the liquidated damages clause were, well, first of all, capped damages entirely, i.e. they could only recover liquidated damages up to the limit of the contract price, or number 2, whether the liquidated damages clause could run beyond the end of the contract, i.e. until they found a replacement or whatever. And the second issue that arose was to do with the wording of Article 12.3, which set out that the cap did not apply in the case of negligence. And the question before the court was whether the term negligence was to mean negligence in care and skill provided, or whether negligence should take on a separate meaning provided in tort. So a really interesting points, I think, to discuss. And shall we kick off with some general thoughts? I'll kick over to Maggie, I think. What do you think?
I have some difficulty with some of Lady Arden's analysis, I suppose. Essentially, I would say that it's rather generous in terms of interpretation of that wording, but I can see the force behind it. It's a sort of pragmatic and practical view of it, because if you look very closely at the wording, a sort of literalist, and that's where I think Lady Arden is trying to steer us heavily away from, would say that the wording is really only designed to impose liquidated damages if the work is done by the contractor, in this case Triple Point, but is late. And so in a literal sense, it's arguable, and that's probably why it got to the Supreme Court, because Severine, you were wondering why the hell did this get to the Supreme Court. It is arguable, therefore, that the clause doesn't apply at all if the works are never completed by Triple Point. And I suppose one could argue that, liquidated damages clause is a surrogate for general damages, that general damages would apply by virtue of the law. If you want to craft something else, something different, something bespoke, then generally English contract law says that's fine, but you need to have pretty clear wording to make sure that a court would recognise, yes, you are trying to do something different, is the reason why it got to the Supreme Court. Somebody did argue that the wording simply wasn't clear enough to apply on these particular facts. And Lady Arden uses rather probably quite a quaint phrase that I haven't used myself for 30 years. And I'm not sure if I've heard it, but she said, oh, well, to construe it in that way would be to throw the baby out with the bathwater. That's a rather a quaint English phrase, but if I try and translate it for people who may not have heard that sort of phrase, it's not used that often, I don't think, anymore. I think what she's trying to say is that would be to have an end result which is so extreme as to destroy the main purpose of what you're trying to achieve. In other words, when you're bathing the baby, you don't want to lose the baby. You want to throw the bathwater away. And if you're throwing both away, that is destructive of your entire core scheme. And so what she's trying to say is, all that wording is saying is the end point will be completion. So liquidated damages can't run beyond completion. But what it's saying is that doesn't mean that there are no liquidated damages if there is no completion. Just trying to nail down that absolute endpoint. So I can accept entirely two different ways you could read that. And the way of the majority is perhaps much more practical, pragmatic, realistic. I have a wee bit of difficulty just sort of intellectually that, you know, if you're, as I've said at the beginning, if you're trying to cast something that is different from the general law, then you really need to sort of take care with the wording. And if you don't take care with it, it's not that they don't have any claim at all for damages. That's not true. It's just that they would have to prove the amount of the damages. Instead of having this liquidated, is the phrase we use, liquidated damages, this precise sum that has been written into the contract, you have to damn well show what your daily rate of loss has been. And so the advantage to you is not having to go through that rigmarole and the difficulty of proof, and perhaps not being able to prove any at all. So that's why I have some difficulty with it. I don't know what Severine thinks.
Well, that sounds to me like you're going with. I mean, Lady Arden gave us three options, didn't she, in what it could be? And I would. That sounds like you're going with option one, which is the Glanstoff case. In other words, the clause doesn't apply at all.
Yes, we mustn't run away with this case, I think, as being laying down very clear principles of law, which is probably coming back to Severine's point. Actually, it's not. It's purely on the interpretation of the wording of this particular case. So that Glanstoff case is again not a matter of principle. It's a matter of interpretation of the wording. And I suppose that's an interesting facet that came out of this case. The current vogue, if you like, or fashion, at least in the English, probably Court of Appeal and Supreme Court now, is to start, if not end with, this is about interpretation of the contract. That it's become a very powerful force behind many, if not most, of our contract law judgments at the moment. Let us answer this by understanding what the language is, rather than is there a new principle of law to come out of this.
But interestingly, also the interpretation of the language in light of the party intention, rather than looking at the wording as you were saying and saying, well, actually, if you did want to do anything differently, you would have had to be more careful. So I thought that, and from that point of view, Lady Arden was quite interesting. Séverine, why don't you give us
I think, yes, you're right, Maggie. When I was reading the case, I was wondering why on earth did it come to the Supreme Court, because I guess it's good. You've just mentioned the Glanstoff case. So I think one of the reasons why is suddenly, appears to have been used by the Court of Appeal as really, really important, even though actually the parties didn't even mention it, from what I understand. So I suspect that's, the main reason why there was a need for clarification, for a point of law. But yes, so I would slightly disagree with you, Maggie, in relation to as to whether that is a recent trend for, using, contract interpretation as the main tool. It seems to me that it's always been there. I remember, the first lecture in commercial law when I studied a few years ago now, the person taking the course, Professor Brigade, mentioning a case where it was the bread and butter of the High Court, and so therefore the Court of Appeal, and so I think that's not really surprising that they have gone on to the interpretation. But it suddenly makes you think, and especially in the light of what you've said about, throwing the baby with the bathwater, what is it that they are saying effectively? So, my understanding is that the liquidated damage clause only applies up to termination, and after that it's normal damages. That seems to make complete sense. A contract ends, when a contract ends, the contractual obligation and what the contract says ends as well. So on that seems to be fairly normal.
Well, I don't know. There's an interesting point trying to get out of that one, actually. I think if you look very hard at what people were arguing in this case, nobody was contending that the damages ran beyond termination. The argument was whether this clause was engaged at all because of the wording of the contract. Yeah. So it wasn't, strictly speaking, it wasn't an issue whether the damages continued to run into the future. Mm-hmm. And it's actually your icon, Lord Leggett, who sort of trails his coat, if I could use that phrase, as to that being a possibility that the damages could run beyond termination, even though, as Lady Arden is saying, well, the primary obligations, she's going on about photo production, Securicor, the primary obligations have ended at termination. That's right. But that doesn't necessarily tell you that there can't be damages continuing beyond, because a liquidated damages clause could provide for that. But Lord Leggett says, but very sort of low key, because it wasn't really an issue, he says, well, hang on, you'd have to look at causation. So the losses then might very well not have been caused by, in this case, the defendant, would have been caused by, say, the new contractor who's brought in after termination. So he's using causation, which is quite sort of Hoffman-ish, if you like, as a tool. And I think Lord Burrows agrees with that. So that seems to be perhaps their thinking for the post-termination possibility. I don't know what you think about that.
I think on the literal reading, I think there are only really two options here. And that is, and I think in that respect, Leggett is correct. And actually Lady Arden mentions them as well, is that either the clause doesn't apply at all or it applies beyond termination. On a literal sense, that is what the clause is saying and is realistic. But as Lady Arden then concludes, and believe it or not, I agree with her, I think that cannot be what they had in mind. I think they had the liquidated damage clause in mind for a specific purpose. Now, it's a bit odd to think that commercial parties of this side didn't have in mind that the contract could be terminated. I mean, that is a little odd.
Well, that the whole thing wasn't very well crafted. No. So you wonder, quite what went. I mean, it's very easy for us and for any courts with the benefit of hindsight to look back at contractual wording and say, this is very badly put together. But that's with the benefit of hindsight. When you know the facts as they are, perhaps it then becomes clearer how it should have been drafted, if that makes sense. But I suppose that's the point I was trying to sort of think in my mind at the beginning when you asked what I thought about this. If you looked at the language there, the whole implication to me is that the parties just didn't comprehend the possibility of Triple Point not ever completing this work. Yeah. And that's all that they had in their minds when they were crafting this clause. That's why I have some problem. So it's sort of almost creative judicial work to say, yes, well, it applies elsewhere.
I think it's just when you look at, so it's regarded as a construction contract, even though, as Tim said, it was for software. But as Lady Arden said, it was not just software. There were also some deliverables. So, that is quite an interesting application of, what we consider construction contract to be brick and mortar contract. But I guess it's because from what you can see in Legat and in Lady Arden, this is something which is actually quite common in the construction industry. I have had a quick look at, what was said by practitioners, and that clearly this is something which is a well-known problem about, the work not being completed. And of course, the one thing which we need to mention is the fact that it's the work being completed and having been accepted as having been completed by Triple Point. By
PTT.
Yes, PTT. Sorry,
PTT.
By PTT. So
it doesn't help that one is TPT and the other is PTT.
I know.
Does it?
And so I think that is in my little mind, it makes sense. But the fact that the question was never asked seems, or did it need to be asked? So yeah, it's a bit of a unremarkable decision on that point. Damn, I've said it.
What I quite like was Lord Legat's starting point to say, well, okay, what have they inserted this liquidated damages clause for? And I think from that point of view, that's quite interesting, right? If we look at the other liquidated damages clauses that went before, MacDessie and so on and so forth, they were protecting another interest that is there. I could imagine, therefore, that if we're reading it in light of what the purpose of the liquidated damages clause is for, it does give us a bit more insight in how it should then be applied in this sense. So in here, it does seem to be a form of motivation, not just a prediction of the damages, but a certain amount of motivation, right? A daily rate, a certain amount of motivation to keep going. And so from that point of view,
well, here's the interesting line between a penalty clause and liquidated damages clause. And here's a good example of it being a bit loosely drafted. They actually use the word penalty. Which is perhaps ill-advised, but the Supreme Court have no difficulty in sort of waving that away and say, well, it's everyone agrees that this is not a penalty in the sense of, as you're mentioning at MacDessie, something offensive to English law as a matter of public policy, because that is striding into punishment. And remember, we can't do that, students. We can't have a clause which is punishing a defendant contract breaker. This is geared towards compensation. So insofar...
Unless, of course, it is a primary
Yes, but
element.
Insofar as this provision is enforcing a contractual obligation and designed to arrive at compensation, it's not offensive, it's not a penalty, and it doesn't matter what label you give it. So I suppose, Tim, you're saying that the rate was devised in such a way as to incentivize or motivate Triple Point to comply. And I suppose, Severine, to sort of answer your point about why the hell did this get to the Supreme Court, I guess on the maths, on the money, as it were, there was a sufficient riding on this clause being enforceable compared with what you'd be able to show by way of general damages, that even making allowance for the very expensive QCs, etc., you were still ahead of the game if you were successful on this. So that's kind of, it all sort of stacks up that this was perhaps, shall we say, a generous rate so far as the customer, PTT, is concerned. Otherwise, they wouldn't have gone the distance with this, would they?
No, I think the incentive is clear. I think it's mentioned both by Lady Arden and Legat, and that is, I guess, the core of the issue. If the contract is terminated before the work is completed, to what does the clause cover? And the idea that if it doesn't apply, then I think Legat, but also Lady Arden, made the point that then there is no incentive on the contractor to avoid delays, and so that has to be wrong. But then on the other hand, if it does apply, it is regarded as, in construction contract, looking at what practitioners are saying, the original employer, as it is referred to, pays for something that a third party is in charge of. And so that, then we have to as always, balance the interest indeed of not punishing the original employer for not completing the contract, and etc., etc. So these are the issues.
The motivation point was actually quite strong, I think, with Lord Leggatt, because I think he was saying that if this clause didn't apply at all, then the contractor would have every incentive not to complete if he was in difficulty. To get out of this penalty, if I put that in quotes, completely. Yes. And he found counter commercial, I suppose.
Yeah, absolutely.
And I think that's quite compelling, isn't it?
Yes.
That is a very good point. I think he makes. Whether the parties ever thought of that is a different question.
Well, that's coming back to my unease at the beginning. It's creative, I think, in a sense, to see the problems that I don't think these particular parties probably did see. Do you think?
The creative point, I would agree in relation to, I was quite sorry, I go on about Leggatt, but he did mention at some point that it was not right in law and in justice. So yes, maybe the court, and whilst Lady Arden did refer to commercial certainty and commercial practice, but so yes, I probably would agree with you, Maggie, that it is creative on this, but it seems to refer to something that is clearly a problem in construction contract. So by solving it, I guess that is by solving it clearly.
I suppose there are some lessons for practitioners, and I'm not sure students would get much out of this, but in terms of practitioners now, you can look at this wording and it's a sort of wake-up call to try and improve the language that you use. Look at the problems that these parties got themselves into. Yes, the Supreme Court dug the client PTT out of a bit of a hole here, I think. But, forewarned is forearmed, that people are coming latterly and drafting these clauses, as you're referring to, Severine, that they are now take even further care to make sure that perhaps there are two clauses here, one for liquidated damages up to completion, on the assumption that it takes place, and then for further clarity, belt and braces, a statement that liquidated damages will run notwithstanding the termination of the contract at any point. Do you see what I mean? That's the way practitioners operate, isn't it? To look at a case and think, okay, can we learn from somebody else's woes, as it were?
Yes. Well, hopefully, it puts to bed an issue that seems to be prevalent in construction contract.
But Lord Leggatt's argument about causation is one.
Yes.
To try and nail this down, that you're going to have a causation problem because, as Severine, as you were saying, if a new contractor comes on to finish off what the outgoing guy has left in a mess, if there's any problems because of that new work, as it were, it hasn't been as a result directly, at any rate, causationally, of the outgoing contractor. It is more indirect.
Is it?
Well, yes, because, that would be the argument, but because the incoming contractor, if there's still problems, as it were, the outgoing contractor will argue that these ongoing problems are not caused by my failing. They are now caused by the new guy that you have engaged. So you've got a causational argument between the new replacement contractor and the outgoing one in breach. That's what Leggatt is trailing his coat. That's the phrase I use. That would be the argument that liquidated damages might be a problem for any clause, however you craft it, because beyond termination, those ongoing losses, have they been caused by the original party in breach? It's just an argument. We don't know. We don't have a case on that point yet. But on the facts, on any new case, that there would be something to be argued about there, I think. That's what he's saying. Lady Arden didn't talk about that because it's strictly speaking, it wasn't in issue. So he's just left this hanging in the air to say to practitioners, hey, chums, think about causation if this comes up in the future, because you might well have an argument on that score. Does that sort of make sense? Have I made sense about
Yes,
that?
I suppose he also makes the point in line with that it would be depriving the parties entirely of the whole purpose of the liquidated damages clause,
Yes.
and knowing their financial exposure if it went beyond termination. Which actually, on that slightly related
It's about
to that,
control, isn't it? He
Yeah.
would be saying, how can the party originally in breach, in this case Triple Point, have any control over what an incoming new contractor is doing or not doing?
yes, yeah,
They can't.
and also, of course,
True.
that eliminates
They
the whole purpose
don't.
of knowing what the damage is going to be, because they're not in control.
Yeah.
Yeah.
The certainty and predictability is lost. Yes.
Yes,
That's the main
absolutely.
attraction, isn't it, of a
Yeah.
liquidated damages clause?
Yeah. Yeah.
That said it much
avoiding-
better. I would like to, and that brings me back to, I made a little note, Maggie, I think I should remember who was saying this, but one of you said at the beginning, before I get it wrong, one of you said at the beginning that this is quite a specific case and isn't really trying to create much of a principle. But actually, if we look
That's
at
probably me.
what
That's
Legat
probably
says,
me, sorry.
I think it was. I think what Legat says at the end, I think sounds to me like we're getting a principle. He's not at the end of his part. Paragraph 86, he says, I conclude that it is ordinarily to be expected that unless the clause clearly provides otherwise, a liquidated damages clause will apply to any period of delay in completing the work up to, but not beyond, the date of termination of the contract.
Yeah, but that point is not in issue in this case. So he can't actually categorically say, hey, chums, I have made a new bit of law. Here it is.
No, but I think again, I can't point at which point of their judgment, but I think both, well, especially Lega does mention that it's a really specific case and therefore it is not raising. I guess the point that he makes on causation does give us food for thought.
Yeah.
Which is bound. So yes, it is very specific to this issue and this issue only, but clearly this is something which in construction contract has been ongoing for a while, and therefore the point of causation does open the possibility of a general point of law.
Yes, but it's also saying to practitioners, you need very, very clear language, I think.
Yes.
And you'll have some difficulties on a causation argument.
Yeah.
It is possible, I suppose, to draft it so it has a very loose causational linkage required, but he's sort of flagging up to us to say, look, this is going to be difficult for you.
Yes. And I think it will all go back to the commercial context because, again, all of them have said, this doesn't reflect commercial reality, and therefore that's why that interpretation by the Court of Appeal is not right. So here again, we open the Pandora box of contextual interpretation and whether it makes sense in that context.
But I suppose that's an interesting thought too. I've only just thought of that. But to what extent judicial reasoning led by what practitioners assuming to be so? Is it that way round? Is it that way round? Should it be that way round?
That's a really now we're getting to meaty stuff. This is contract law reflecting reality, or is it building principles and policy as we would like them in society? Oh wow, Maggie, you've opened up.
Who's leading who, I suppose, is what I'm saying.
So again, going back to, my commercial law days, it was always clear that, the debate of whether commercial contract facilitate or regulate commerce, and, the very famous decisions where it says that actually the law follows the practice, the law should facilitate, and we see that in retention of title clauses and things like that. So here with liquidated damage clause, something that is used very often in construction contract, I would say it is practice raising a question which the law should listen to and give effect to as much as possible, but without bending the general principles. But the general principles should also take care of looking at how practice evolves. I mean, on a pure...
So could one say the judges are for the grey areas of uncertainty, but if it is commonly accepted approach, that is going to be very, very forceful.
Yes.
in the mind of a court. So it's almost resonant with, do you remember Lord Steyn?
Reasonable expectation
20,
of the
30
parties.
years ago.
Yeah,
he
all
talked
back to
about,
that.
yes, the reasonable expectations
It's always that, yep.
of businessmen, and these days we'd have to add business women.
Or business people.
Are a very forceful power behind a judicial reasoning. So if nothing else, this case illustrates that. I
suppose the court has the added difficulty that they have to think about the doctrinal coherence.
Yes.
Of these principles beyond just what is happening in practice. And I think that's probably their primary obligation is ensuring that we have that coherence within the system. And then the secondary question is, okay, and what is actually happening on the ground, and can we reflect that in the law? But I think it is from that point of view the secondary position.
Yes.
Yeah, no, I agree with that.
And to me, the fact that this is regarded as a construction contract, even though it's for software, even though, again, Lady Arden with the distinction of saying, it's not just a software, since there are deliverables upon which strict liability applies for the defect.
Yes, but I think that's more about that other point that Tim wanted us to talk about, the limitation of.
I know, that goes to the
losses.
Second issue. Yeah. But nevertheless, it is interesting that this is classified as a construction contract, and all the cases that were referred to were much more traditional brick and mortar, building of a bridge, so I think it is.
But isn't that just because the parties have used the construction industry model template, and so that they've taken that on themselves, as it were, so that is the approach the court's naturally going to give to it. I think that's fair enough.
Therefore that goes back to the question that you raised earlier, or Tim, that you raised in relation to what's the law about. So here it's just the parties using something that is in existence, that the standard form for construction contract, because there is nothing else, because arguably the debate on what the status of software is still a problem in English law, generally speaking, aside the Consumer Rights Act, but in B2B contract we still don't know. So I think that is therefore the who leads who. The practice uses the tool that they can, but are those tools? But anyway, I'm digressing onto a different point here.
Well, let's jump right in, shall we, to that second point, because otherwise time will run away with us as usual. Let's have a look at the whole idea of this wording, negligence. Severine, do you want to start? What do you think?
So again, it's something where when you read the decision, to me that makes perfect sense that the word negligence cannot have a sui generis meaning, that it cannot exist on its own. And so again, these questions, it surprises me that they have never been asked before. So to me, the fact that the Supreme Court considered that the word negligence also applies to breaches of contractual skill and care makes perfect sense. But I can see that contractually, again, we can see that maybe the parties had something else in mind, so that the contract did give us so many words for gross negligence and negligence, so making the distinction here. So it makes, to me, of the majority of the Supreme Court, makes complete sense, but I can also see, if I can edge my bet here, in the dissent of...
Because I'm about to disagree.
Good.
Yeah, me too. I'm ready to go.
So I will let you jump. But I can see, if I can just have that on record, that I can also see the difficulty of dissenting judgment of Lord Sales, or is it Lord Hodge?
Tim, you disagree. You say what?
Well, let me jump in. Yes, I'm going to abuse my position as discussed today. So one is, generally we do give, if a wording has an accepted meaning, and this will come back, I think, on my second point to what Maggie you were saying right at the beginning. But if we have an accepted meaning of the word negligence, then surely that is the one that should apply. And if we take the context of this particular contract, it would tend to make sense. I think what the law is, or what the court is relying on here, is that actually they didn't take much care when they were drafting this contract. And the second point, which I think is quite compelling, and Maggie, this was yours at the beginning, I think, was they shouldn't have used the word negligence. Right? That's not the word you would use here when you're talking about exercising skill and care. So I do have a lot of sympathy here for Lord Hodge and Lord Sales, of course, on that point.
I suppose we ought to explain to students the sort of context of why we're talking about this one word, because it's sort of, we're plucking a word out of the whole thing. Yeah. A student reading this, you might have some difficulty with it. If I very quickly explain what it is, it may make more sense what we're going on about. It starts with the liquidated damages provision, and then it says there will be a limit of liability on the supplier, triple point here. So the total liability of the contractor shall be limited to, and it has the wordings, the contract price. So that's them trying to contain their risk. And that in principle is fine. And that's part of the bargain. And so we don't approach this in any rigid or restrictive critical view, because the parties have arrived at that as part of their bargain, and presumably the contract price reflects that limitation of damages possible. The third point that the Supreme Court decided was that the liquidated damages would be part of that overall cap. But then the clause that we're now arguing about is there is an exception to the cap, as it were. So we're putting back liability, which is a very peculiar way of doing it, I think, if you're a student. So you first say that there is a limit of liability, and then you say, no, but for the purposes of this limit, the following don't apply. So we're putting back the possibility of unlimited damages. Obviously, you've got to be able to prove what your damages are for certain specified things. So sometimes people talk about an exception to an exception, which is a bit peculiar, but you see where I'm going with this. And that's why we're going on about the word negligence, because the putting back of unlimited liability was for a little string of things, as it were. The first one was fraud. Well, I stop and think, well, actually, that's a very serious thing, actually. So it would be a rarity, hopefully. Fraud is deceit, is lying.
Yes.
And naturally, this is the realm of tort law, not contract law. Now we're getting sort of closer to, hang on, can we understand this word negligent? And then it goes negligence. Now that's Severine's point and Lady Arden's point. That negligence actually, in common speak, is a very broad thing and basically means carelessness. Yes. And so that might be carelessness, contractual carelessness, as well as carelessness that the tort law, you students, second year students doing that, you would be studying that now. And then it has gross negligence, which is an extreme form of carelessness, if you like. And then it ends with willful misconduct, which is quite a serious thing to allege because you've intentionally misperformed. Now, this is where I disagree, I think, with all due respect to Severine and Lady Arden.
I like the way you put me before Lady Arden.
well, you're here and you might hit me, whereas Lady Arden doesn't know who the hell I am.
I can't. You're not physically present. I can't hit
quite
you.
Understandably. But Lord Sales and Lord Hodge, I think, is a much more sophisticated argument here by looking at the way in which this clause came into being. So they've looked at the context, and we know from construction of a contract, interpretation of a contract, actually context, I'm not sure I'd say king, but is very important. So they looked at the history of this and they said, this clause started with just the words fraud, gross negligence, and willful misconduct. And then at some point in the negotiations, they put the word negligence in. And so trying to work out what the hell was going on here, they were saying fraud is naturally taught. Yes, nobody would argue about that. Gross negligence, they're saying, well, that's got to mean something more than pure negligence. Otherwise, there's no purpose to the word gross. So Lord Sales, Lord Hodge say this is contract and tort, okay? And then the word willful misconduct is naturally more contract. To willfully misperform, we are naturally looking at contract law. But to put negligence back in and to give the meaning to that word, and only that word, we think that's talking about tort, but only tort. Do you see where I'm going with that? So to have this unlimited liability, it would have to be something arising from fraud. You couldn't show that. Or something arising from gross negligence, which is a severe form of lack of care, whether tort or contract, and they couldn't show that. Or willful misconduct, that is sort of intentionally breaking the contract, intentionally fouling things up. They couldn't show that. So they were backed to negligence, but negligence means only tort type of negligence. So you'd have to find some tort-based wrong that the software suppliers, Triple Point, have failed to deliver, as it were. And they couldn't find anything on these facts. Ergo, this clause didn't bite, wasn't engaged on these particular facts. That, I think, is what the minority were arguing, and I personally, I can see the force behind that. I don't know what you think.
One point, though, that Lady Arden, I think it was Lady Arden, said quite nicely, was that they couldn't actually find any examples of negligence.
Mm. Well, Lord Sales disagrees. Yeah. I think he thought there were examples as to whether breach of a tort nature was actually very likely, and so they were asking counsel for examples of when you think, or when your client thinks that might have arisen. So if there is no possibility at all, that is perhaps undermining an interpretation of a word. But I suppose there's an answer to that too. When people are crafting these contracts, they will try and think of the most likely consequences or occurrences, but they won't necessarily have every conceivable thing in mind. And there is a tendency when you're drafting to draft on a sort of what I might call belt and braces basis. You haven't thought of an example yourself. Nevertheless, for completeness sake, you put that word in case the unforeseeable happens, and you've got a word that covers it. So the fact that they can't find or think of any examples, I'm not sure that takes you a hell of a way.
No, that's true.
I mean, the point that you were referring to, Tim, as to the example, I think it's on the point of what would happen on the first point, and that's a paragraph 82 of Lord Legate. So I think that is slightly different. But again, it all goes back to what is the meaning. So I am convinced by Lady Arden says that it doesn't have an independent meaning. And to me, the fact that surely it includes a negligent breach of contract makes sense.
But would it have been different then, Severine, if I play with you for a minute, if the draftsman had used a phrase that I might naturally think of myself as lack of reasonable care?
Yeah.
And if they had chosen that or used that anywhere else in the contract, because remember, we shouldn't really look at simply one clause, we should look at the whole thing. Yeah. If they've used that construct somewhere else, that is an indication that the draftsman thinks about it being different.
So even though always say to students, what is negligence? It's carelessness. So by the fact that there is an obligation of care, of using skill and care in performing the obligation, if you don't do it, it's carelessness. Here, I think it was very clear that Triple Point had a litany of failing to give, enough people for the contract, etc. So they were careless. Therefore, clearly, to me, there is a negligent breach of contract. They haven't given it everything that was necessary to perform the contract. Therefore, here, by the fact, so to me, I will reverse what you said. By the fact that, can you give me an example of an independent negligent example, that it is negligence has an independent meaning?
Well, people were playing with the idea. I think I don't have the judgment in front of me, but things like, for example, one of the employees for Triple Point, the software company, might have been on site for the client and done something that would be recognizable as a wrong so far as tort law is concerned. So perhaps they are attempting to fix somebody's computer, or they drop a step ladder or tool on somebody's head. You know, that they are more naturally taught and only taught. Are you with me?
I think that they did make the point of, you know, whether it is, so I think it's Lady Arden who makes the point that actually it is conduct in the contractual performance, but here you are saying that it's not linked to the performance of the contract?
Well, that the contract gives the opportunity for someone to breach an obligation which tort law would recognise, but the contract is not required for the completion of the tort law cause of action. So, for example, I am an employee of Triple Point and I'm on site of the customer's premises, and I do something which causes damage or harm to someone else while I'm on site. The fact that there is a contract between my employer and the customer gives me the opportunity of being on site, but it is not really the cause of my failing, as it were. My failing is purely a tort one. I run someone over in the car park driving into the customer's premises that morning, for example. But you wouldn't say that was a contractual lack of care, would you? You would say that was a breach of a tort law obligation that a motorist owes to a pedestrian.
Okay.
I'm thinking off the top of my head here.
But Lady Arden would say, and you would say, Severine, but that's a fanciful example.
No, not necessarily. I'm trying to think on my head in relation to, you know, causation and vicarious liability and all that. So
yes, my employer would have vicarious liability for me.
Yeah.
But as soon as you start using that language, vicarious liability, at me, Severine, I'm thinking tort law.
And I suppose I'm thinking off the top of this. This is not scripted and not thought through, so this may go nowhere.
None of this is scripted. We hope it's thought through, but it's not scripted.
Mine was clearly not scripted.
Well, that's
either.
true. There's nothing here is scripted.
With that excuse, thank you.
Dear. All those cases that you've mentioned, Maggie, would sound like they would be insured against.
Well, insurance is an entirely different matter.
Well, but no, because that could go to the intention of why that's in there, right? In terms of drafting the contract, that would be something that you would foresee, right? You would say, okay, this is something that we can take liability for because, well, we know we're insured for it anyway.
Well, you could possibly say that about most of the clauses that are about liability. They may, if they've been thinking about it, have thought about, well, what is possible in terms of insurance and what is possible in terms of the risk, the allocation of risk. It's very difficult, I think, to get insurance for bad performance of your own contractual performance.
But that's it. So that's why that would strengthen your case for saying,
yes. Well,
actually, in the negligence in the kind of strict negligence sense can go beyond the cap because we've got another contingency. In other words, you know, we're all within this is part of the financial planning of the whole project, right? The negligence element is pushed.
They would have had to have come up with some evidence that supports that sort of background matrix, as it were. This explains the genesis of the language used in this clause. I don't think anybody went that road.
Just because I didn't go there doesn't make it part of the drafters no. planning. You know, if you think about that clause, okay, Ford would probably not fall within that.
Yeah, okay.
But you could see why someone would go beyond
so
the
naturally
cap if they knew that was covered.
Well, you see, you look at the language of that clause that is putting liability back beyond the amount of the cap. And if you ignore the word negligence for a minute, what they all, the rest have all in common, I would say, is very serious misperformance in some sense. These are serious things to allege. Fraud.
Yep.
And gross negligence, willful misconduct, that, they are extreme things. So, I'm not sure you could use the phrase that we use with legislation about justum generis. My Latin's not up to it, Severine. You will know what I mean.
Don't look at me like that.
My Latin. Meaning, if you've got a string of words that are sort of united together in this way, they take their colour and meaning from one another.
Yes.
And it's negligence that is the odd man or woman out here, if you understand that sort of phrase. It's a peculiar one because all the others are very extreme forms of behaviour. And then when you put the negligence back in, it's almost like you've suddenly changed direction, suddenly changed gear. And that, I think, is why a lot of the difficulty was had here.
I wonder whether it is... So we know the contract took about 6 months to be negotiated, and I suddenly wonder whether suddenly they remembered, oh, yes, in my contract law days, I was told that, if you want to exclude negligence, you'd better put it in. I don't know.
No, I don't think we'll ever know.
So that leads us really to whether or not we think this case was correctly decided. Séverine, what do you think?
Yes.
Right,
short.
that's.
I agreed all the way with Lady Harden, so I can't say it was wrongly decided.
And Legat, you're always going to agree with anyway.
I suppose I am more lukewarm. I am more lukewarm in my approval, and I actually prefer, I think, the approach that Lord Hodge, Lord Sales took to that exception, or the exception to the exception. So yes, on balance, a grudging yes.
A grudging yes. Well, I think with a grudging yes is probably how we can end most of our podcasts. To our listeners, of course, thank you very much for listening. Next podcast is going to be our 10th podcast, and I think we know which case we're going to be doing.
Is that the economic duress, I think?
I think it is. Pakistan International Airlines. We've been waiting for that for some time.
Yes.
So that'll be our 10th podcast. Do tune in for that. Thank you very much for listening, and if you do want to get in touch, of course, do email us. You'll find our email in the description below, unpacking.contract.law@gmail.com. Thank you very much.
Thank you.
Goodbye.
Bye.
Bye.